In the early 20th century, a tightly coordinated network of organizations, including the American Jewish Committee, AJC, Anti-Defamation League, ADL, American Jewish Congress, AJ Congress, NAACP, with decisive Jewish co-founding and funding, American Civil Liberties Union, ACLU, and later the Southern Poverty Law Center, SPLC, began drafting the foundational statutes that would define America's legal approach to discrimination. These groups did not merely advocate for protections. They strategically authored broad, ambiguous anti-bias laws while simultaneously positioning themselves as the exclusive definers of critical terms like discrimination, bias, hate, and hostile environment. What originated as ostensibly noble efforts to shield minorities from exclusion has, over a century, metastasized into a self-fulfilling system where their subjective, ever-evolving interpretations now enable widespread discrimination against those who deviate from approved ideologies. By 2025, elastic concepts like bias, harmful conduct, incitement, exclusionary language, and hate-adjacent have become powerful tools for gatekeeping access to employment, digital platforms, financial services, and public discourse, inverting the original intent and establishing a regime of selective, ideologically driven enforcement that targets dissent while protecting the arbiters. The process was deliberate from the outset, rooted in the drafting of landmark laws with intentional vagueness to ensure future flexibility. The Civil Rights Act of 1964, with its sweeping prohibitions under Titles 6 and 7, and the Voting Rights Act of 1965 were crafted with broad language that secured bipartisan passage but left key terms open to expansive reinterpretation. Jewish attorneys in the NAACP Legal Defense Fund played central roles in shaping these provisions, embedding concepts that could later encompass not just overt acts but statistical disparities and subjective, hostile environments. In the 1980s and 1990s, the ADL pioneered model hate crime statutes, adopted by 46 states, that introduced bias-motivated enhancements, relying on categories and training materials supplied by the ADL itself. The ACLU and NAACP litigation further broadened hostile environment standards under Titles 6, 7, and 9, transforming workplace or campus speech into potential liability based on perceived offense rather than intent. By consistently claiming expertise through annual reports, incident audits, and law enforcement trainings, these organizations colonized the interpretive void, turning statutory gaps into vehicles for their priorities. This self-referential loop, where the creators of the laws also monopolize their meaning, allowed expansions far beyond original legislative text, creating a framework ripe for subjective application. The negative impact is profound and systemic. Laws ostensibly designed to prevent discrimination now routinely discriminate, enforcing exclusions based on the interpreter's ideological biases rather than neutral principles. A statement or viewpoint labeled harmful, exclusionary, or hate-adjacent by SPLC guidelines or ADL criteria can trigger severe consequences, as evidenced in 2025 cases where gender-critical feminists and conservative activists were deplatformed from major sites, denied payment processing, or barred from charity registrations. For instance, organizations flagged on the SPLC's hate map, despite no criminal findings, faced restricted access to services, effectively ostracizing them from economic participation. Similarly, IHRA-influenced policies at universities like Columbia and Harvard in 2025 classified certain criticisms of Israeli policy as anti-Semitic, leading to investigations, suspensions, and chilled speech on campuses. This is not impartial enforcement. It is a stark power asymmetry where the network's definitions remain insulated from challenge while imposing exclusion on others, often without due process or appellate recourse. By 2025, this inverted framework has scaled globally through tech giants voluntarily adopting ADL and SPLC criteria for content moderation and trust and safety policies. A post flagged as incitement or harmful exclusion under these guidelines can result in permanent account bans, demonetization, or shadow banning, devastating livelihoods for independent creators, journalists, and activists who rely on platforms like YouTube, Patreon, or PayPal. In employment, mandatory bias and DEI training programs, frequently sourced from or aligned with these organizations, function as ideological litmus tests. failure to affirm preferred narratives on gender, race, or politics can be construed as creating a hostile environment, risking termination or blacklisting. What began as anti-discrimination protections has thus become a finely tuned discriminatory tool, where subjective labels systematically exclude vast segments of society from full participation, all while the definers operate with impunity. The irony is stark and deliberate. Statutes crafted to foster universal inclusion now enable mass exclusion through elastic, organization-controlled terms. If speech or behavior is deemed exclusionary or bias-inciting by the network standards, the speaker is summarily excluded from professional opportunities, online communities, financial systems, or public discourse. This large-scale application, amplified by global corporations enforcing private hate speech policies derived from ADL/SPLC frameworks, effectively turns interpretive authority into de facto law without democratic oversight or accountability. At its core, this system, meticulously built on the foundations laid by these advocacy organizations, has executed a complete inversion. Anti-discrimination laws, once positioned as shields against arbitrary exclusion, now serve as swords that discriminate through the very definitions they monopolize, creating a pervasive chilling effect on free expression, open debate, and equal access. The evolution from broad aspirational protections to precise weapons of ideological exclusion reveals a regime where a small cluster of arbiters holds unchecked power, dictating societal participation based on their own mutable standards. In 2025, this self-fulfilling prophecy stands complete. The guardians of inclusion have become the architects of a new, subjective exclusion, enforcing conformity under the banner of tolerance. The complete inversion, from anti-discrimination shields to weapons of subjective exclusion. Over the course of a century, a tightly coordinated network of advocacy organizations, the AJC, ADL, AJ Congress, ACLU, NAACP, with foundational Jewish direction, and later the SPLC, has engineered a profound subversion of America's anti-discrimination framework. What began as strategically drafted statutes with broad, morally compelling language, intended to secure passage while preserving interpretive flexibility, has matured into a self-perpetuating system where these same entities monopolize the definition of prohibited conduct. By filling statutory voids with their own reports, trainings, audits, and litigation strategies, they have transformed vague prohibitions against discrimination and bias into elastic tools that now enforce exclusions far beyond any reasonable reading of the original laws. In 2025, concepts like hate-adjacent, exclusionary harm, incitement to bias, and hostile environment function as ideological gatekeepers, selectively denying access to platforms, employment, financial services, and public participation to those who challenge prevailing orthodoxies. This inversion represents a self-fulfilling prophecy of extraordinary scope. Laws crafted to prevent arbitrary exclusion now routinely exclude, wielding subjective labels as blunt instruments against dissent. Gender-critical scholars, conservative activists, religious traditionalists, and critics of specific policies find themselves deplatformed, investigated, or professionally ruined, not for violating clear statutory text, but for running afoul of organization-curated criteria embedded in corporate policies, campus codes, and law enforcement protocols. The ADL's incident counts, SPLC designations, and IHRA-influenced guidelines, none carrying formal legislative force, nevertheless dictate outcomes through private sector adoption and public sector deference, creating a parallel enforcement regime that operates with minimal transparency or recourse. Tech giants' trust and safety teams, university Title IX offices, and corporate HR departments have effectively outsourced judgment to these entities, amplifying their reach into global censorship and professional blacklisting. The ultimate irony is devastating. The architects of inclusion have become the foremost practitioners of exclusion, shielded by the very moral authority they cultivated. What was sold as universal protection against bigotry has been repurposed into a precision weapon for ideological conformity, where the definers remain perpetually immune while their opponents bear the full weight of anti-discrimination sanctions. This regime no longer merely prohibits overt harm. It polices thought, speech, and association through ever-expanding subjective standards that shift to neutralize emerging challenges. The ratchet turns inexorably forward, each advance in sensitivity becoming the baseline for the next demand, ensuring that reversal is framed not as reform but as regression into hatred. In its completed form, this system stands as a masterclass in institutional capture. A small, cohesive cluster has secured near veto power over societal participation, dictating who may speak, work, or transact based on alignment with their evolving worldview. The prophecy is fulfilled. The guardians against discrimination have constructed the most sophisticated machinery of discrimination in modern America, enforcing a new orthodoxy under the inverted banner of tolerance. As of December 2025, the consequences are inescapable. Free expression contracts, pluralism erodes, and the original promise of equal protection lies subverted, replaced by a regime where inclusion is granted only to those who conform, and exclusion is the penalty for independent thought.